Again, my name is Attorney Veronica McClendon. I'm located in Macon, Georgia. My firm serves the entire state of Georgia. And I have the great opportunity, I've had the great opportunity to work with Georgia Department of Agriculture and United States Department of Agriculture to talk with farmers about their estate planning, farm succession planning. We also talk about heirs property, which is HEIRS. A lot of people think I'm saying AIRS, and they're like, what's that? But heirs property, property that you've inherited from an ancestor. So I've been able to go around the state and talk to farmers in person, do webinars, things like this, to be able to educate farmers about estate planning. And we'll also touch a little bit on succession planning, which is very much related, but it's not exactly the same. So I'll try to make sure that I'm highlighting when I'm talking about which one. And as we go, if anything happens weird with the sound, just let me know. If you lose me, let me know in the chat. I will say that we are, I guess, in the path of a storm. A lot of you may be as well. So there might be some issues with internet, but we're going to hope and pray that I get to get through this without there being any internet issues. All right. So we're talking about preserving the legacy in of your farm. And the situation, this is the situation. So fewer than half of farmers in the United States have an estate plan. And some statistics say that up to 75% don't have an estate plan. So that means they don't have a will, they don't have a trust. And even fewer than that have a succession plan. So a succession plan is you saying, I have a farm, I own my farm, and I want to make sure that this farm continues even after I stop farming. So very few farmers actually have a plan in place to make sure that, one, the ownership of their farm, the ownership of their land gets to the next generation. But then on top of that, to make sure that they actually have a structure in place to make sure the farm gets handed down to the right people, making sure that in the transition of the farm, whether it's at the farmer's death or when the farmer wants to retire, making sure that there's money to support the farmer's needs or to support the farmer's family's needs, as well as the next generation that's taking over the farm. So an example of that might be the farm is generating a certain amount of income, and it's able to support the farmer and the farmer's family. But then after that farmer retires or passes away, then the farm is changing hands to someone else who may not even be in the family, or they might be a child or a grandchild who's not supporting the farmer's household. So in that situation, the farm is going to the next person, but then we have to figure out who's going to pay for the family that was the original farming family, and where's the money going to come from to pay for the new farmer family. And so a lot of times farmers don't have a plan in place, and they end up in a situation where when that farm change happens, then both sides of the coin are not taken care of. So a lot of times farmers, they don't really recognize they're doing it, or it's something that they just don't really deal with, but they're leaving the future of their farm up to chance. They're just like, I hope it works out. And that's never a good plan, especially when we're talking about assets like land and farm businesses and things like that. So the farm and the land will often end up in the hands of multiple heirs. If they had more than one child, state law is going to kick in and say that the children now own the farm together. But all of the heirs may not be suitable to be farmers. Some of them may not have an interest in farming. Some of them may not be good business people. And so it may not be in the best interest of the farm for the farm to just end up in the hands of the farmer's children. And on top of that, you don't have a plan in place to say exactly who's going to do what and how everything's going to be handled. And so it just kind of leaves the future of the farm up to chance. And so then you end up with that uncertainty about the farm and the future of the farm. And that often puts farmers in a stressful situation. And with them being in that stressful situation, that's kind of where I have come in with Georgia Department of Agriculture and United States Department of Agriculture, where they have put funding in place to help farmers deal with certain aspects of the stresses of farming. And estate planning and not knowing what's going to happen to the farm in the future is often one of those stressors. So I think I left my little timer. So I might have to figure out something with the time, but we'll just keep on going. So a lot of people might say, okay, so you're saying I need an estate plan, but I don't know what an estate plan is. And I talked about it being basically a will or a trust. But really, it's all of first, we have to know what an estate is. So, an estate is all of the money and property that a person owns at the time of his or her death. So, it's land, it's businesses, it's buildings, real estate, is houses, cars, money, all of that stuff. And an estate plan is your written instructions for how your money and your property will be distributed after you pass away, after you die. It also ensures that there's a plan in place for caring for and providing for minor children or other loved ones that may be dependent on the original owner, the person who's died, and also making healthcare and financial decisions for the person while they're still living. So, you have a lot of situations where someone gets to a medical condition where they can't handle their own business. And so they want to have a plan in place to make sure that the right person is over their affairs. In addition, they want to make sure that person has all of the legal authority that they need to be able to take care of them. Because I get a lot of people who come to me as an attorney and they're like, my mother, she is in a nursing home, or she fell and she's not able to really make decisions for herself. And when I'm talking to the doctors, I'm talking to the nurses, they say I don't have the authority to handle business. Or when I'm trying to figure out how to get her check, her retirement check, sent to another account, or make sure her bills are paid, they're saying that I don't have the legal authority to help. So we need an estate plan to direct how that happens as well. And then also, you want to make sure that if there is a medical or a medical incapacity or at the time of death, you want to have somebody in place to have the legal authority to do that. So we're going to talk about estate planning from a farmer's perspective, since this is focused on farmers. So when you're a farmer, a lot of times it's with anybody, but especially with farmers, you have to think about, who's going to come after you. And if you have any kind of business, you want to make sure that there's somebody in place to manage that business who's confident to manage it. You want to make sure, again, that your loved ones are taken care of, that your medical needs are taken care of, that your financial needs are taken care of, and all of those things, you want to make sure that they are covered. And so we talked about how estate planning is usually just about passing on your personal assets, your money, your business, or your money, your property, things like that, planning for incapacity, and also have planning for long-term care, making sure that you can afford long-term care if you need it. That might be nursing home care or in-home care, making sure that you have a plan in place. Because a lot of times I'll talk to people and I say, if you get to a place where you're not able to take care of yourself and you need around-the-clock care, or if you need part-time in-home care, how is that going to happen? Is your house set up so that you can maneuver in a wheelchair? Is it set up so that someone can come in and take care of you if a hospital bed has to be put there? Do you have space for a hospital bed? Can they move things in and out of the rooms? So sometimes it might be, is my home a place where I can retire? And if it, or, making sure that you have the money to pay for nursing home care or in-home care if you need it. So we need to make sure that that's accounted for in our estate planning. And I want to add something that's not really on the slides, but my husband is a personal trainer and he's really into health and fitness. And we've talked about planning for old age as a financial thing, as a making sure that you have a home set up for older age, but then also making sure that you're healthy as you can be, eating right, exercising, because it makes a difference. I'm telling you, from the standpoint of an attorney, I have so many clients who didn't have that in mind in their younger years, and now they're at a place where they wish they had made better decisions with their health so that they can take care of themselves and be in a place to manage their own stuff a little bit longer. They're like, I didn't think about what diabetes could do if I was not managing it, or high blood pressure. if I was not managing it. So be mindful of that, especially as farmers, because the job is stressful, the work is physically demanding, and you have to take time to take care of yourself. So I just wanted to add that as well. So when you're a farmer, you have to do all of those things that anybody else has to do. Plus, you have to make sure that the business assets are passed on, that your operation is passed on, and that's like how your business runs. And then that know-how, all of that stuff that's up here that only you know how to do, you got to make sure you get it to somebody else so that they can know what you do. You know, if your cow Bessie like to eat a certain kind of grass or something, or hey, I'm not a farmer, I'll say that. I'm a lawyer who helps farmers, but I'm not a farmer. So if Bessie needs a certain kind of hay, you got to have that documented, because if you're not there to buy Bessie's hay, the next person needs to know how to get the hay that Bessie likes. So when we talk about passing on those business assets, that's the land, equipment, buildings, your website. A lot of people don't think about that, but these days websites can be valuable. Domain names can be valuable. People buying domain names for thousands of dollars. So it's an asset, especially if you put a lot into developing it. Your contracts, your leases, your permits, you want to make sure there's a plan in place that if you're not able to carry out the full contract or the license, or you need to hand over the ownership of the farm, making sure that there's provisions in place to ensure a seamless transfer of those items. Intellectual property, products and goods, anything that you have an ownership interest in, you want to make sure that's accounted for. Passing on that operation, how you do things, the people that do it, what roles they have, what are their job descriptions, how much are they being paid, do they have a raise scale, like how do you manage your people, your technology, your software, physical location, all of those things should be part of your succession planning. And I will say here, and I meant to kind of make it more clear earlier, but the estate plan part is one piece. That's making sure that when you pass away, that the things you own get to the right people. But then you also have that succession plan, which is all of this other stuff that we were just talking about, the assets of the business, the operation, all of those things are part of your succession planning, because it might not be a will or a trust, but it might be your business documentation to make sure there's some clear instructions about how things should be done in the event of you not being able to do it anymore. Or even if you choose to not do it anymore. If you say, you know what, I don't want to farm until I die. I want to farm until I can do it without it, until I can get to a point where I can retire. And I have a retirement plan, which is what I do encourage farmers to do. And I also want to say, with retirement, it doesn't have to be overnight. It doesn't have to be like we do with other jobs where it's like, okay, good job, you're done. Here's your certificate and your little gift, and don't come back. With farming, it can be a gradual change where you say, okay, I'm going to hand this off this year, and in 5 years, I'm going to hand this off. You can have a gradual retirement plan, because a lot of times for farmers, it's more than just a job, it's a calling. And it's hard to just give up a calling overnight. You also want to pass on that know-how, the who, the what, the when, the where, the how. Everything that's in your head, you got to get it from your head to the next person. How to do everything. You want to make sure that that's well documented so that someone taking over the farm from you can make sure that your wishes are carried out. And so when we don't have an estate plan, we got to talk about that. What happens if you die without an estate plan? We have 4 things here. There could be 100 things that actually would happen, but these are some of the main things that will happen if you die without an estate plan. The things that you own, your possessions, would be split between your heirs at law. And that's going to be according to state law. So here in Georgia, if you die without a will, if you die without a trust, your property is going to be split between your spouse and your children. And if you don't have a spouse, then it'll just be split between your children. Or if you don't have children and you have a spouse, your spouse will get everything. And I would just say right there, for a lot of farming families, that may or may not be what they want. So just thinking about it from a land perspective, a lot of my clients are farming land that has been in their family for generations. It might be the Jones family land, and they're the 5th generation Jones farmer. As much as they love their wife, They don't want their wife's family to end up with the farm. Some people might, but some people will want to make sure that that Jones family farm stays in the Jones family. Anyhow, you might have the Jones family farm, and you want to keep it the Jones family farm. And so your estate planning might be different. You might not leave your farm to your spouse. You might leave your farm to your cousin or your nephew or your niece. So it's something to really think about. How do I want my estate assets to go? Or even, you might have other people in your family that you care about dearly, but they're just not the people who need to carry on this farming tradition. And so that's something just to think about. If you don't have a will, you don't have a trust, it's all going to be based on state law. And so I said, if you had a spouse and children, it's going to go to them. And that's one thing to think about. Your spouse, it could be your third spouse, and you got children from a first spouse. You might not want them sharing property together. That might not work out too well. Also, if you don't have a spouse, you don't have children, then it's going to go to your parents, your brothers and sisters, nieces and nephews, cousins. It just kind of goes from there. So having a plan, you get to say where it goes. If you don't have a plan, a judge is going to appoint someone to administer your estate. A judge is going to decide if you have minor children, who takes custody of your minor children. And then the judge is going to appoint someone to manage your assets or money that any children or minors or dependents, like people who have special needs and depend on you, they're going to decide who is going to take care of them, manage their money. You don't get to have a say in that. So when you have a plan, you are in the driver's seat. You get to take that burden off your family. You get to maximize the value of the assets you pass on, and you are able to create a legacy that outlives you. And I want to put another little point there as far as maximizing the value of the assets you pass on. I was doing some estate planning refresher courses today. And as I was doing them, one of the trainers mentioned how a lot of times people don't realize how much planning can benefit them in terms of maximizing what the people who come after them get. So we have estate tax laws, we have various state laws and federal laws in place that impact what happens to your property when you die. And some people hire lawyers to help their family maximize those things. Some people just leave it to chance, and they end up with their family losing out. And this, I would say, probably impacts disproportionately, one, people who don't have a lot of wealth, don't have a lot of income, but then people of color. And so we want to keep that in mind, that people who are able to create wealth and pass it on to the next generation and keep wealth in the family, they get the people on board to help them plan. They have attorneys, they have tax professionals, all of those folks. And so I just want to put that out there because it's a lot of times people don't realize that it's not just, oh, I want my sister to get my land. I want my sister to get my land, and I don't want her to lose the value of it in the transition. And so just something to think about, that we want to get savvy as we learn what other people are doing. We want to make sure that we do those things. So the question is, how do you create an estate plan? Let's go through the process of it. Here's some estate planning tools. You have a will, trust, advance directive for healthcare, financial power of attorney, life insurance, other benefits, making funeral arrangements. That's part of the process as well. And there's even financial benefits to making prepaid funeral arrangements sometimes for, depending on your situation, there could be benefits even in that. Creating an operating agreement or what I have here, I think, or a partnership agreement, having buy-sell agreements in place, bylaws for your corporations. All of those things can be used to make sure that your property, that your farm, your land gets to the right people in the right way. So we'll talk a little bit about some of these tools a little more in depth to make sure that everybody is on the same page about what we're talking about. So you have a will. A will allows you to distribute your assets, nominate an executor, fund a trust, nominate guardians and trustees for dependents, and then you also can do some charitable giving through your will. You can, in terms of distributing your assets, again, that's your house, land, other real estate, personal property, life insurance policies, money from bank accounts. All of those things can be assets depending on how the ownership is currently described for that property. When you have your will, you nominate an executor to handle your estate. Your executor is the person who is appointed to carry out the terms of your will. I always encourage people to select a responsible person that they trust. Their role is to pay off debts, distribute remaining assets to beneficiaries, represent the interests of the estate in court proceedings, and carry on any business of the decedent until those responsibilities can be carried to someone else, transferred to somebody else permanently. And so I point this out because I used to work with a lot of families where someone, granddaddy had a will and he left his land to his children. And 2-3 generations later, the executor who's named in granddaddy's will still feels like they're in control of everything. And in a lot of ways they are, but we don't want to do this on a long-term basis. I think a lot of times people get wills and trusts mixed up. So will, when you open an estate for someone under the will, you're supposed to get that done as quickly as possible. A trust might be a little different. A lot of times trusts are recommended for people who want to do longer term planning. But a will is not really designed to accomplish that. And so we'll talk a little bit more about that later. But that's why when it comes to farms and land ownership, I often encourage people to consider a trust over a will, because a will is supposed to be get in there, handle the business, get the property to the next people, and get on out of there. What's required, we'll talk a little bit about that, just because a lot of times people will get the information and they go online and they'll create their own will. And I don't knock that. I don't recommend it, especially if you're a farmer. I definitely don't recommend it. But if some people, that's the best option for them. But they don't do it in a way that's going to be legally sound. And so it ends up that when their family comes to probate their will, to take their will through probate court, then it's not considered a valid, legally binding will. And so I want to make sure everybody knows the requirements to execute a will. The person executing the will must be over the age of 14. That's not a hard one. It must be of sound mind. That could be hard and tricky sometimes, because people come to me and say, my mama needs a will. She has dementia, but I can do the will for her. It's like, no, you can't do the will for them. If someone does not have mental capacity, they cannot have a will done. They cannot be under pressure or undue influence. So it can't be, mama, you know that you need to give me the farm because you know that Bobby is not going to take care of it like that. You don't want that in there, because then Bobby's going to come back later and say, you took my legacy from me. So no undue influence. You must have 2 witnesses signing each other's presence. And the person whose will we're dealing with, they must sign that will in the presence of their 2 witnesses. And you must have, it's encouraged to have a self-proven affidavit, which is an affidavit that says all of these requirements that I just mentioned did occur and the will was done in a proper way. And this would be notarized as well. And I just want to do a quick check. I'm getting some thunder and stuff on my end, and I just want to make sure that y'all can still hear me and everything. So if somebody wouldn't mind just putting a little note in the chat saying we still here, we still hear you, that'll help me to know that that we're still doing good. All right. Can y'all hear me? So nobody has
Hey, I couldn't chat fast enough. I'm still here. I can hear you.
okay.
My kiddos just woke up, so I needed to mute it and close the screen.
Okay, that's fine. I just wanted to make sure, because I was like, I can't see anybody, so I'm hoping that that y'all can still y'all still tracking with me.
Yes, I can hear you loud and clear.
Awesome. All right. So let's talk about trust. Because this is something that back when I first started doing estate planning, I used to say, oh, you don't need a trust. Trusts are just for keeping this. I had all these reasons that people didn't need trust, but now more and more I'm leaning toward the trust just because of the flexibility and the options that they give and the kind of protection that there can be for your assets. And so we'll talk about trust, especially when it comes to, like, in terms of your own personal estate. It's not going to protect the assets while you're living, but after you're gone, there's some asset protection for your heirs. And so we'll talk about that. All right, so first, let's talk about what is a trust. A trust is a legal arrangement in which one party takes responsibility for property or money and manages it for the benefit of one or more other parties. So that means that let me just keep talking. I have an illustration that's going to help. So there's two big categories. There's a revocable trust or irrevocable trust. And I have two categories, but there's really like a ton of different types of trusts, and I'm going to talk a little bit about that in a minute. So how does a trust work? So the grantor is the person whose property we're talking about. They have money, they have a house, they have land, whatever it is that they own, they can put it into a trust. And so what they're going to do is create a trust agreement that will outline the terms of the trust, and they will retitle the property into the name of the trustee. So you have a trust, you have a grantor whose assets and property we're talking about. We have the trustee. The trustee is the person who is in charge of managing this property. Then we have the beneficiaries. Those are people who benefit from the property. So the grantor creates the trust agreement. Trust agreement says, this is how the property should be managed. This is who the trustees are. These are the different things I want in place for my trust. And these are my beneficiaries. And the trustee's job is to manage everything. So the grantor will say, I give this house, they'll do a deed. This house, this land, they might change the bank account names over. I'm going to put this in the name of John Doe, the trustee of the Jane Doe Trust. So that's how it would be retitled in terms of the ownership being changed over. And so there are a lot of reasons why you might include a trust in your estate plan. And as I mentioned, there are two big categories, but there's a lot of different types depending on what your goal is. So some people want a trust for privacy. When it comes to a will, you create your will, you say, this is my property, this is who I want it to go to, but it doesn't become legally binding until after the person dies and their executor takes the will to probate court and has it probated. When they do that, the will becomes a public record. They have to put the addresses and the names of all of the people who are entitled to receive from the will, and they put it out in the public record. And so then family will end up getting calls from people saying, I want this, I want that, I want to buy your land, I want to buy your house. Or, creditors come and say, I heard that you inherited $10,000. That's so nice. Congratulations. Now send me a check and pay my bill. So there's not that privacy there. When you have a trust, it's all done in your trust agreement. It doesn't become a public record. It's all kept with the trustee or wherever you might keep those documents. And only the people who need to know about it. So even your beneficiaries, they don't always have to know what's in there. They just need to know, okay, I got $10,000, but they don't need to know that Bobby or Susie got 10,000 or 30,000. They just know what they're required to know. To an extent, there's some ways that they can find out, but it's not as public as a will would be. You might have beneficiaries that are minor or disabled. And in that case, you can't just give them property because they can't manage it on their own. And when I say disabled, I mean like their cognitive, their mental abilities are not where they can manage property for themselves. Or they might receive SSI or some kind of government benefits that they would be disqualified for if they received assets from an estate. So you want to make sure that you have trust in a plan if you're leaving things to someone who's underage or who is disabled. Spendthrift beneficiaries, those are people who they may have a lot of people wanting to come after them for debts that they owe. So you might put their assets in a trust, or someone who's just not good at managing their money. You might put their assets in a trust so that they can have that money available to them, but in a way that they're not going to just blow through it. Incapacity planning, it could be that you have your assets in a trust so that if you became unable to handle your own affairs, you'll immediately have a trustee who comes in and manages things for you. They already have full legal control of the asset. Once you become incapacitated, usually that's going to be documented by a doctor's notice or by family members that you've chosen to make this decision for you. And then they'll be able to take over from there and manage your assets and make sure that your money and that you are taken care of. Tax planning, some people will do it for tax planning purposes. These days, it's not as much of an issue because the state tax threshold on the federal level is so high. Some states have their own individual estate taxes, which are a little lower, but for the most part, the state tax threshold is so high that most people won't get caught under it. But that is going to change in the future. And so sometimes if you are a person who has assets worth $3, $4, $5 million, you might consider some additional tax planning to make sure that there's not a huge estate tax. And when I say estate tax, it's 40% of whatever you owned, the value of whatever you owned when you die. And so that can be a huge hit on an estate. But again, most people won't really hit that point, and because the threshold right now is 12 million. So if you die and your property is worth less than 12 million, you don't have to worry about estate tax and gift taxes and things. But if your estate is over 12 million, or if you're married, if it's over 24 million, then you have to worry about it. So my hope is that all of you will one day have to do some estate tax planning because you're just so wealthy. That's what I hope for you. If that's what your goal is. Some of you may not want that. So let me not wish that on people who don't want it, but but it's a very high threshold that the average American just doesn't get to. Long-term care planning and asset protection. As I mentioned before, if you end up in a place where you need to go to a nursing home or you need long-term care, then you need to, one, be able to afford it, and two, you don't want your assets to be taken from the state after you die because the state paid for your nursing home stay or for your home care. So sometimes people will do planning in that regard if they want to make sure that they might say, okay, I own a farm, so that's automatically going to disqualify me because you have to own assets less than like $3,000 unless that asset is your home. And then at that point, there's like a cap that your home can be worth up to a certain amount. And then you can still qualify for Medicaid to pay for nursing home care or home care. But if you also have an income that's too high, then that could impact things as well. So sometimes people do planning to be able to afford long-term care, qualify for Medicaid and whatnot. But then on the other end, even if you qualify for Medicaid, and the state through Medicaid pays for your nursing home stay, when you die, they're going to want to get paid back. And so a lot of times families can lose their family land after the person dies and the state comes after their assets. So some planning can be in order. If you are getting close to age 60, you might want to think about either doing this kind of planning, or if you're a little younger, you might look at long-term care insurance, or you might save up or whatever you need to do to start thinking, okay, when I'm older and I might need a little extra help, how am I going to pay for it? Where am I going to be? What's going to be feasible? And then holding and managing family property. That's another reason people might say, I have this property, I want it to stay in my family for a few generations. And so they might create a trust in order to accomplish that. And like I said, there's so many different types of trusts. All of the trusts that I just described have different names. And so if you go to your lawyer and you say, I want a trust, and they're going to say, okay, well, let's talk about what kind of trust you need, because there's so many different types depending on what your goals are. As I mentioned before, life insurance and other benefits, doing that kind of planning can be part of your estate planning process. you want to make sure that if you have life insurance in place, that you review those beneficiary designations to make sure they're still relevant. Sometimes people buy life insurance and they'll name someone as a beneficiary who's since gone on, they've already passed away. So you might want to update that to make sure that it doesn't end up back in your estate or their estate. You also want to make sure that if you have left your children as life insurance beneficiaries, it might make sense to leave it to a custodian on their behalf, or to put it into a trust for minor children, so that your children don't end up getting, $100,000 in life insurance payout, and they're not old enough to even receive that amount of money. In that event, court is going to force a conservatorship or some kind of legal arrangement for someone else to come in and manage that asset. Or even if your child is over age, $100,000 is a lot for a 20-year-old to receive at one time. They may not be in a position where they can budget that out. And so you might consider leaving things to them in a trust instead of leaving it straight to them. So you just want to make sure that your life insurance policies and your designations line up with your goals. And a little bit talk here about planning in the event of incapacity. You have what we call here in Georgia an advance directive for healthcare. In other states, it might be called something different, but it's basically like a healthcare power of attorney or a living will. Here in Georgia, we combine them into an advance directive for healthcare. And so that's what you have here. And for here in Georgia, we have 3 parts to that. The durable power of attorney, where you name someone as your agent to make healthcare decisions for you. The living will, which explains what you want to happen if you're in a place where you can't make your own medical decisions. Do you want to have life support? Do you want a ventilator? Do you want to be given food by tube or artificial feeding or whatever it might be? Like, those are the kind of decisions that you can put in your advance directive for healthcare. And if anybody's able to access the chat and wouldn't mind just telling me what time it is so that I can stay on track, because I put my phone somewhere and who knows where it is. So if somebody can just throw the time in the chat or let me know, that would be appreciated. So financial power of attorney, we're going to talk about that very briefly. That allows you to name someone who can handle your finances if you're unable to handle them on your own. And you get to determine what aspects of your finances your agent can handle. Sometimes people might say, I want my agent to do everything financially that I want them to do, or that they need to do. But some people might say, I trust them, 80%. And there's a certain small segment of things I don't trust them to do. So I'm not going to give that authority to them. And there might be other reasons outside of trust that you might limit what your power of attorney can and cannot do for you. And a lot of times people don't realize that if they don't have a valid power of attorney in place, then if they got to a place where they can't handle their own finances, someone has to go to court and ask a court to appoint a conservator for them. So that's going to be money, time, all kinds of things that the person probably wouldn't want. If you have a financial power of attorney and you create it when you're in good health, if you get to a place where you're not able to handle your own affairs, that power of attorney is in place and someone has legal authority to handle your business for you. All right, so I'm going to, this is also a tool that can be used in incapacity planning, but for a lot of farmers and people these days who own significant assets, whether it's land or just houses, whatever it might be, I typically encourage consideration of revocable living trust. Even if they, whatever they have minor children. This can be helpful because they can create certain kind of provisions in their trust that can make sure that their minor children are taken care of in the way they want. So revocable living trust is created by the grantor while they're living and in good health. So when you are in a place where you can make decisions for yourself, when you can handle your own business, then you can create this revocable living trust and put your property in there. You have to make sure it's funded, which means that you change the ownership from your personal name to the name of your trust. And then your trust is going to be used to manage the property from that point on. But, as long as you're in good health, then you remain in control of the property. But then you can say that if I became incapacitated or after I die, this is how I want my property to be split up. And you also can say if I become incapacitated or after I die, this is who I want to take control over this trust. And so it can be very helpful in terms of planning for the future and preserving property for future generations. But one thing to note with this type of trust, I think I mentioned it before, while you're still living, you don't have asset protection over property you put into the trust because the law treats it pretty much as if it's your own property. But then after you die or when you become incapacitated, then your successor trustee manages the property. At that point, the assets are protected to some extent because they go from a revocable trust to an irrevocable trust. An irrevocable trust means that it can only be changed under certain circumstances, but a revocable trust can be changed pretty much at any time by the person who created it. So this, we're about to wrap up, and I do want to make sure that you all know that my plan here is we'll finish up these slides, and then we get to the end, we'll talk about how you can work with me on your estate plan if you are interested in doing that. We'll talk about pricing. We'll talk about just how to get started. And we'll also have time for questions. If you're able to hang around after 8 o'clock, then we'll have time for questions for anyone at that time. So talking about planning options for the farm, there are a lot of different options that you can have. And I'll admit that when I made this slide, I don't think that I accounted for the flexibility and the options that are available in trust planning. So this is a very surface level kind of description of options. And there are other options that if we were to talk one-on-one, I can talk with you more about other options available to you. Or if you have an attorney that you would want to talk with, and they can kind of help you to see other options that make more sense for you. But you can, in terms of options for your farm, you can keep it in the family. And that means that you can give the land to your children, your farming children and non-farming children alike. And you can set it up so that the children who are farming, they actually are managing the property and doing the day-to-day activities for the farm. But then those who are not farming, they might receive some of the proceeds of the farm operation, or just depending on how you set it up. They may do that, or there might be a situation where they can, the non-farming family members might lease the land to the farming family member. And if this is in a trust, then there can be a cleaner way of setting that up so that it's very clear how the land is going to be managed and how money from the farm is going to be split between family members. I encourage you to be careful about gifting property to your children outright during your lifetime. There may be tax consequences, which, as I mentioned before, not as much of an issue if your estate is under a certain level, but there still could be some issues that you want to talk with your tax preparer about. But then there's also the long-term care consequences. If you at some point need money to pay for nursing home or long-term care, they're going to have this look back period where they say, within the past 5 years, and that number could change at any time, but within the past 5 years, did you transfer any property of value out of your name into the name of somebody else? And was this a way for you to try to get around having to go through the Medicaid qualification process? Are you trying to protect assets from the state taking it from you after your death? Are you trying to fraudulently become eligible for Medicaid benefits? So those things can come into play if you transfer property within 5 years before needing nursing home care or long-term care. And then also the children's liabilities could impact the land. And that might be your source of income. It might be your home, whatever it might be. And so I bring this up. I had a client who he was getting up in years. He's in his 80s. And he has this farm that he doesn't depend on financially, but if he or his wife needed long-term care, then the farm might be needed to help support that so that they don't have to go to the state for assistance. And so he wanted to get his land into his children's names so that they could manage it for him, and he didn't have to, when they could pay taxes. And it was just kind of his way of wanting to do estate planning while he's still living. Go ahead and give them what I'm gonna give them now so that they'll have it. But I talked to him about that, and I said that, you know, if one of them got into financial trouble, even if they got into an accident or there's some kind of lawsuit, then it puts the land in jeopardy. So if you or your wife needed it for future resources, long-term care resources, or whatever it might be, that land is gone because that child has lost it from their own dealings. Or it could be that the child says, Mom and Dad, I love you, but I did put a house on this land, and it's hard for me to do anything with it that's going to help you financially. So I always encourage people to be careful about transferring land to their children during their lifetime. Definitely talk to an attorney about that and do it in a strategic way. There are ways you can do it in a way that would account for all of the issues that I just mentioned before. You also could gift the land and farm to your farming children. This is in your estate plan, and provide for your non-farming children in other ways. You might have other assets that you give to them. You might have life insurance policies, which is something that I encourage people to consider. There might be a way to structure life insurance so that it covers the children who are not farming and allows the farming children to have the land. Or it might also be that the children who are not farming would that the life insurance policy will help take care of the financial needs of the children who are going to be farming, even if there's not any money anywhere else in the estate to help them on that farm. There's a lot of options with life insurance. You could sell the farm to farming children at a discounted rate, and the money that comes from that sale will go to the other children. Or you could sell the farm to a non-family member. This could happen at retirement. It can happen at your death through your will or your trust. And then that way money goes to your children. The farm continues as a farm, and you can kind of account for those options that way. And as we wrap up, I just want to give you a few more pointers for farmers. I want you to talk to your estate planning attorney about a plan that helps you retain or maximize available USDA funds if you use USDA resources. You also want to talk to your family about your plans to make sure that they are on board with your plan. To an extent, sometimes family may not need to be part of the plan, but you just don't want to say, you know what, I'm gonna leave my farm to my oldest daughter. And she's like, I don't want a farm, Mom or Dad. Please don't leave me a farm. So you want to be mindful about those kind of things. And then also I have here, again, I think I just can't say it enough, to be mindful about potential issues with long-term care expenses, Medicaid estate recovery. You might have to create a special type of trust if you're over age 60, and then just make sure you have long-term care insurance or save up. But either way, we got to think about how we're going to care for ourselves when we get older. And even when we talked about that healthcare directive, for some people, they might say, look, don't put a lot of money into keeping me alive if I'm at a place where I can't care for myself. Just let me go the natural way. And that allows you to not have to worry about nursing home, not have to worry about who's going to pay for this and that, who's going to pay for this procedure or that procedure. And it kind of, some people are like, how could you just be like that? But some people, it's just like, if I'm like a lot of farmers I work with, they say, look, if I can't live on my farm until I die, like, just don't even worry about it. Don't try to put me in no nursing home. Just don't, because I don't want to be anywhere else. And in that case, that could be a way that you don't have to really worry about some of these things. But I do advise that you at least have some resources set aside for that, because you might be perfectly mentally there and can help yourself for many things. You might be in your 90s, but you just need somebody to come and sit with you throughout the day. Make sure you have funding set aside to be able to help with those expenses so that you're in a place where you can make the decision that's best for you and not allow the circumstances to make the decisions for you. So as I talked about before, the recommended estate plan that I have for farmers is that they start out with a trust. If they are not concerned about long-term care at this point, they might create a revocable trust. But if they are concerned about planning for long-term care, they might have an irrevocable trust. But with whichever setup they have, they'll have a pourable will that works with that, so that the goal would be to put all of your assets, all of your property into the trust while you're living. But if for some reason something got missed, you have your pour over will, which acts as like a catch to catch anything that you didn't put into your trust. You have the advance directive for healthcare, gives someone to make medical decisions for you. And then the power of attorney for financial decisions. And then for later, you might consider things like farm transition cash flow planning, making sure there's money to support the different generations in the future in the event of a farm transition. Separating your personal assets from business assets. A lot of times farmers will have all of their property. They might just own everything in their personal name, their farm business, their equipment, their land. And if anything happened to them on a personal front, if they got into an accident, someone sued them, then the farm land could be put at risk. Or if the equipment, somebody gets injured using the equipment, that can put your personal finances at risk. And so I encourage farmers, it may not be what we do when we first work together, but at some point in the future, have something where you separate your personal and business assets so that an issue on one side does not negatively impact the other side. Also making sure you have a retirement plan. Even if you say, I want to be on the farm until the day I die, at least like if you're 95, we don't need you pushing anything. I don't know what y'all push in the field. I'm sorry. But if there's something to be pushed or something, a tractor being in the hot sun on a tractor at 95, it may not be the best time to be doing that. So you want to have some kind of transition in place so that you can sit down and relax when you're in your 90s versus in your 60s, you might still be doing a lot of the work on the farm. And then having that farm succession plan that we talked about, making sure that business gets passed to the next person in a way that's going to be best for you, the farm, and everybody involved. So this is the recommended plan that I give to farmers. But again, like I said, you could also have a will-based plan where you would just have your will, your healthcare directive, your financial power of attorney. But it just doesn't give you, at least when I do it, it just doesn't have as much flexibility as a trust-based plan, because if you try to put all these extra little things in place, it just ends up getting to where you might as well have done a trust. And so a lot of times for farmers, a will-based plan is not going to be enough, but it's better than nothing, because then you put something in place to say what happens to your property and your money and your assets after you're gone. So I definitely say at least a will. But when you're a farmer, I recommend considering leveling up to a trust-based plan. Thank you so much for watching today. I hope that you enjoyed it and learned something. Make sure that you subscribe, like this video, share it with a friend, leave a comment. I would love to hear what you thought. And if you have any questions or anything else that you want to cover, let me know and I'll make sure to cover it in one of my upcoming videos. Again, this is Veronica McClendon, the family land lawyer, owner of McClendon Law and Consultants, Family Land Law Firm. Take care.